All right, I'm calling the meeting to order. I have 10:32 as the start time, and I will ask Pamela Brief to take a roll call to establish our quorum.
Thank you. Please say present when I call your name. John Mersinski,
Present?
Andrew Bowden,
Present.
Pamela Brief, present. Susan Landry,
Present.
Patricia Trout.
Present.
All members are present and a quorum is established.
All right, thank you. I'd like to make a few comments to start out. I want to thank everyone for being here today. I think it's been at least 2 years since we've met in person, so it's good to see everybody again in that respect. Anyone who's here from the public, you're welcome to address the committee at the appropriate time in each case, and signing in at the door is an option. However, if you do sign in, you will be listed officially in the meeting minutes. For each agenda item, there will be an opportunity for public comment at that point in time. Committee members, please turn your microphones off when you're not speaking. I'd like to acknowledge Ron Jones, who's with us today from the CAB board, and also Laura Zuniga for being with us as well. In regards to any voting requirements, all motions and seconds will be repeated for the record. Votes on all motions will be taken by roll call vote. There will be a lunch break, probably roughly sometime between 11:30 and noon, maybe a little bit later than that. And at this point in time, I'd like to offer the opportunity for any of the other committee members if you have any comments that you'd like to make at this time. Okay, hearing none. All right. I would like to offer an opportunity if anyone in the public would like to comment on the agenda, or I should say non-agenda items at this point in time. You have an opportunity to do so. I will also state that any issues that are brought before the committee will not be able to be discussed at this point in time, but may be agendized at a future meeting. So is anyone here from the public that wishes to speak? Okay, hearing none. I would like to make note that we recently received a document from UCLA Extension that addresses some activities and changes that are going on in their program. We will not be able to discuss this item today. However, it may be agendized at a future meeting. So with that, we will move on to item D and ask Brianna Miller, Manager, Board and Bureau Relations, to present an update on the Department of Consumer Affairs.
Thank you. All right, can everyone hear me just fine? And webcast? Okay, thank you. I hope I'm not going to regret my decision bringing up a hard copy as opposed to my computer. So we'll see how this goes. Well, good morning, committee members. I'm Brianna Miller with the Department of Consumer Affairs Board and Bureau Relations. Thank you for allowing me an opportunity to provide a department update today. I'd like to start my update with a note about the transition back to in-person meetings. As you know, on April 1st, DCA's boards, bureaus, commission, and committees returned to meeting in accordance with all aspects of the Open Meeting Act, including publicly noticing all meeting locations. Legislation is in progress, which would permanently allow boards and committees to meet remotely while also providing both virtual and physical locations for members of the public to participate. If AB 1733 is passed by the legislature and signed by the governor, it would take place immediately. We cannot be certain that AB 1733 will be enacted or when, but I know we appreciate the flexibility and increased access that come with both in-person and remote meeting options. Recently, Board and Bureau Relations distributed to all board and committee members guidelines and requirements to adhere to when conducting in-person meetings. In sum, this communication addresses requirements for meetings under the Bagley-Keene Open Meeting Act, making sure you adhere to local public health guidelines at a meeting location, face coverings, and vaccination verification and testing. It also includes some signage that boards can post at meetings regarding masking. DCA has also shared guidance and tips from the California Health and Human Services Agency to reduce the spread of COVID-19 for in-person meetings. If you have not done so already, I encourage you all to review these documents. Additionally, as you are preparing for your upcoming meetings, please do not hesitate to reach out to Board and Bureau Relations for questions. And next, I'll discuss COVID-19 safety measures. DCA appreciates all board members and staff who have continued to serve through a pandemic that has affected all of us in so many ways. State public health guidance has relaxed mandatory face coverings, but masks are still strongly encouraged in indoor settings. And in high-risk settings such as healthcare facilities, face coverings are required for everyone regardless of vaccination status. Local orders may be more restrictive to respond to community conditions, so please be aware of changing public health guidance and remember that as state representatives, we are all expected to adhere to state and local guidelines. Next, I'd like to transition to some departmental news, starting first with DCA's Enlighten Licensing Project. This work group was formed in 2020 to utilize licensing subject matter experts within the entire Department of Consumer Affairs. The group's purpose is to help individual boards and bureaus streamline and make their licensing processes more effective and efficient by utilizing best practices, information technology, and cost-saving measures. The first deep dive, which was for the Board of Registered Nursing, has completed, and a report will be released this month with recommendations that can be used by all boards and bureaus to improve their processes. After this successful first round, this work group will soon begin directly assisting another board or bureau. Moving on to key positions filled at DCA. As DCA looks to the future, Director Kirkmeyer continues to build the DCA team to lead the department towards continual improvement and excellent service. Tanya Corcoran began serving as the department's first compliance and equity officer effective March 2nd. Ms. Corcoran will oversee DCA's solid and training planning solutions, organizational improvement office, equal employment opportunity office, and the internal audits office, allowing DCA to better identify and analyze emerging department-wide issues and provide timely solutions to DCA's divisions, boards, and bureaus. Additionally, Terrence Brass joined DCA as the Chief of the Division of Investigation, or DOI, effective March 28th. Mr. Brass brings valuable experience in all major aspects of law enforcement and has also served in the United States Marine Corps. As DFI Chief, Mr. Brass will lead a team responsible for providing investigative services to DCA and its boards and bureaus with the mission to protect and serve California's consumers. And last but not least, Dadong Prahadi was selected to serve as the department's internal audit chief, also effective March 28th. As DCA's internal audit chief, Mr. Prahadi will lead audits efforts to provide independent and consulting services designed to add value and improve department operations. Under his and Ms. Corcoran's leadership, the department's goals and objectives, the Internal Audits Office will assist DCA management in accomplishing the department's goals and objectives by bringing a systematic, disciplined approach to improve governance, control, and risk management. Moving on to the Board and Bureau Relations newsletter. Another communication which you may have recently received from Board and Bureau Relations is our new quarterly newsletter. I am pleased to announce that on April 5th, BBR, or Board and Bureau Relations, distributed the first iteration of the quarterly newsletter titled Board Members, Did You Know? to all of our board and committee members. This newsletter is an outreach tool to keep you informed of various departmental activities as well as information which may be impactful to you as committee members. We hope this is something which you will find helpful and we welcome your feedback for future distributions. And if you did not receive this newsletter, please let us know so that we can make sure we have your correct email address on file. And finally, a reminder about the board member orientation training. And the reminder simply is that Board and Bureau committee members who are recently appointed or reappointed need to attend the board member orientation training, or BMOT, within a year of that appointment or reappointment date. This training is also available to any member who is interested in a refresher. You can register for the BMOT through the Learning Management System, or LMS, which is DCA's training portal. And this year, the remaining trainings will be held on June 15th and October 12th, and they're virtual trainings. And that concludes my presentation. So as always, Board and Bureau Relations is here to help. And if there's anything we can do to assist your committee, please do not hesitate to reach out. And with that, I'll hand it back over to Chair Wyszynski. Thank you.
All right, thank you very much. I do have a couple questions. As far as the newsletter goes, do the editors of that solicit articles from the various boards and that type of thing, or how is that handled?
If there's something that you think would be applicable to all board members or of interest, we would definitely be interested to hear those thoughts and ideas. But the aim is, to provide information about departmental activities, or, Form 700, if you will, that just passed, things that would apply broadly to our board members.
Mm-hmm. All right, thank you.
Sure.
All right. Any other questions for her? Okay, hearing none. Thank you very much.
Thank you all.
Mm-hmm. All right, we can move on to item E, review and possible action on the January 27th, 2022 LATC meeting minutes. At this point in time, I would ask, do any of the other committee members have any comments or questions on that?
Mr. Chair,
Yes.
if you're entertaining a motion, I'd like to make a motion to approve the meeting minutes from January 27th as presented.
All right. There's been a motion made. Do I have a second?
Second, Pamela Brief.
Okay.
At this time, I'll take a roll call on voting for approval of the meeting minutes. John Mrzinski,
Yes.
Andrew Bowden,
Aye.
Pamela Brief, aye. Susan Landry,
Abstain.
Patricia Trout.
Abstain.
With that, we have the meeting minutes approved for our last meeting
All
on
right.
January 27th.
Thank you. I just have a quick question. Do we actually have anyone from the public here at the meeting today that is present?
Mr. Chair, we do not, which is why I wasn't jumping in and asking us to stop for public comment, because
Right, yeah.
we have no public. It's different from online, where we presume that we may.
Right. Okay. All right. So we'll keep an eye on the door in case somebody slips in. All right. We'll move on to item F, Program Manager's Report, and we'll ask Trish Rodriguez to present that item.
Okay, the March 1st Program Managers Report, starting with business modernization. Cohort 2 is in the fourth and final stage of project approval lifecycle. The software vendor has been identified as Inlumon, and the project is anticipated to commence in this spring, here very soon. The next item, the Architects Board. The next Architects Board meeting is planned for May 20th. This item will be discussed under Agenda I. And the committee, at its meeting on January 27th, the election of the 2022 committee officers was held. John Wyszynski was elected to continue as LATC chair, and Pamela Brief was elected to serve as vice chair. The LATC will also develop a new strategic plan tomorrow. DCA Solid will facilitate the session to identify new objectives for the next 3 years. An outreach presentation is planned for April 14th for UC Berkeley. The presentation will be conducted remotely via Zoom. Additional presentations are being planned at other schools for the end of the semester. Under personnel, the licensing administration position was vacated on December 31st. Recruitment efforts included updating the duty statement to include new procedures for fingerprint requirements as well as fingerprint clearance through DOJ. Nicholas Barnhart was selected as a successful candidate for the position and joined the LATC on March 28th. He comes to us from the private sector, where he was an instructional assistant at Sacramento State College for 5 years. Nicholas is here today and will also be joining us during strategic planning. So welcome, Nicholas. On our website on January 1st, the requirement for all new initial license applicants to submit fingerprints prior to the issuance of a landscape architect license went into effect. LATC received Department of Justice approval for California level background checks on February 1st, and the LifeScan form was posted to the LATC's website. The Federal Bureau of Investigation approved LATC for federal level background checks on March 2nd, and an updated LifeScan form was posted to the website on March 7th. There were also a couple of notices posted to our website for regulatory packages, including the Education and Training Credits package and the UC Extension package. These will be covered further in another regulatory update. The LATC set an objective to educate the different jurisdictional agencies about the landscape architecture license and its regulatory scope of practice to allow licensees to perform duties prescribed within regulations. LATC worked with DCA Legal Counsel to add language to Section 5659 of the Business and Professions Code to prohibit local jurisdictions from rejecting plans solely based on the landscape architect stamp. A bill was submitted in January 2021 as part of the omnibus bill. However, proposed language would delay review of other programs and thus removed from the bill. At this time, LATC is planning to include the proposal in the next sunset bill. So I have asked Karen Halbo, our regulatory attorney, to present an update on our regulations packages. So I'm going to hand this over to her now.
Thank you, Tricia. And it's a pleasure to meet everyone in person after 2 years of just being online. I'm just going to follow the order of the materials that Trish gave you, so we're not juggling around here. And starting with... Okay, thank you. Starting with the CCR 2611, that's the abandonment of application, retention of candidate files. That was approved by the Office of Administrative Law, and I believe it was only included in here because they become effective on a quarterly basis. So after April 1st, you can now, if you go online to see what the regulations are, it's the corrected version and it's in place, and this is what the regulation is going forward. So it is a very long process, and that one's done. Next, we have the education and training credits. As you can see from the materials, it's gone on its long and winding journey and was submitted to the Office of Administrative Law. And during their 30-day review, the OAL attorney recommended clarification, change to the language, and told us exactly what he needed. And so second modified text, which the board already approved, went out. There were no public comments. The final documents have been pulled together. We were waiting on CAB's minutes from their vote, and those came just last week. And the OAL attorney was very helpful with us. This was a package that had to be filed in hard copy because it exceeded the OAL limits. And so all of those materials have remained in his office, so he doesn't have to check that we changed anything. And we will be submitting what we'd have down here. It says April 1 that the reg package was resubmitted, but it has not yet been resubmitted because it's not. Technically, we're doing a new rulemaking that incorporates by reference all the documents of the previous rulemaking that was withdrawn. And it still is a 30-day review, up, down, and we've worked directly with the OAL attorney, and I believe we have everything we need to finish this regulation off. It was very nice of him to let us leave all the materials in his office, and I stressed to him this was the highest priority package. So that's where that one stands. On the approved extension certificate program, this was the one that got very interestingly complicated. There were some errors in the minutes from several years ago, the 2019 meeting of CAB, and going forward, the text had not been correct. So CAB voted to revise their minutes. We had a 15-day notice to correct the text. And in working, let's see, we have had a second modified text go out. Normally when you modify text, you start with the existing text and only add in what you see as the changes. And working from the modified text and the revised minutes, a sentence was dropped. And it was a substantive sentence, which was to add in well, it's to add in the statement that one member of the it had to be a committee member. It was one sentence that said must be a committee member. And if you look on the website, this has been added in. And as soon as the public comment period is done, we will submit this. This was also a package that needs to go in as a new package that incorporates by reference, but this one had been electronically submitted and it should be able to be electronically submitted. So that one has moved forward. And on issuance of citations, where are we at with that? Those documents are with me. I believe that's, yes, and that was an initial submission package. We did put some priority on the ones that had deadlines and finals, but I have that, and I see you here, and I know you want it done. On the waiver of fees, after the legislation passed, we had not had any other DCA boards come forward with language for this. And Trish worked hard with me. We put in some language, and we've gotten feedback from the budget office that they need some solutions baked in to make sure that it is not damaging to the program if some sort of broad emergency has trouble. So also Trish is working with the Architects Board because they also are working on this sort of language, and there's some policy choices that have to be worked out, and I'm hoping that it can come to the board at the next meeting, or pardon me, at the committee at the next meeting. On the disciplinary guidelines, you see the long and winding road that it has taken, and I'm excited because it's at the director's office, and she is a fabulous proofreader, and she has the package, and once we get it from her, it goes to agency, and I'm hoping it will go to notice quite soon. Are there any questions? Thank you very much.
Excuse me, I have a question.
Yeah.
Let's see, so for 2615, you said a hard copy had to be submitted instead of an electronic submittal. Can you explain why that happened?
Oh, the Office of Administrative Law had required, before the pandemic, you would bring in an original and 6 binders, so copies. So 7 binders go in, and the paperwork is all just like when we would go to court. You're putting in a lot of things, and with the pandemic, they tried to switch quickly to an electronic system, and we're only able to set up to accept files up to, I think it's 25 megs. I'm not the right person to know that language, but I know the number. And the regulations unit has some very talented folks who would take what used to be a binder and make it into a long electronic document that OAL was very comfortable with. And the board meeting minutes, all of the documents taken together simply exceeded the limit. And so your staff made copies and 7 binders so that could be submitted. And that's why. And OAL is aware that it would make their lives easier if they could take larger submissions, and they're working on a technical fix. But that's the limit right now.
I'm sorry, is there a particular reason why they limited the size of the digital submittal to begin with?
I was told that was simply what, I'm talking to the lawyers, and the lawyers are like me. IT says we can't go bigger. And we don't know the underlying, but I understand that they're trying to address that.
Okay, thank you.
Mr. Chair,
Yes.
I do have a question. This is, I think, more for Trish. Trish, during your portion of the report, and I'm now looking at Business and Professions Code, Section 5659, inclusion of license number requirement. You had said at this time the LHTC is planning to include this proposal in the next sunset bill. When is that next sunset bill? I mean, do we have to, is it like soon, or are we having to wait like multiple months or another year, or?
You want, yeah.
Sure. So it would have been, our report for Sunset would have been due in January of next year. And so we would go through Sunset later on in that year. So that was why I planned to hold it over. I did check with the DCA Ledge office, and they said still typically the legislature likes to see those kind of changes in sunset bills versus, it's easier. But now you'll see in the legislative update, there's a bill that extends our sunset date for a year because the legislature is still, I think, balancing out their hearing calendar. So I will have to go back to a plan B for that one. So I don't have a set answer for you at this point. So I don't want to make it wait an additional year. So I'll have to come up with another answer.
Okay, great, thank you.
I do have one question in regards to Section 2651, the waiver of fees under declaration of emergency. I'm assuming that it's the governor's office that makes that declaration. Is that correct?
Yeah, a declared state of emergency.
Okay, and I would assume that unless it's a statewide emergency, that it would be limited geographically to some area that would be designated by the governor's office.
Yeah, within the declaration. And some of the budget issues is, well, yes, we know you're aiming it at where there's a fire, but the language is broad. And what happens if it's something larger? How do you make sure that you're protecting the program?
Okay, yeah, because my question is, I'm assuming that this, the way it's designed is it won't be automatic, that the licensee would have to apply for relief from these fees or whatever, and would have to show that they either reside or their business is located within this designated area, or their primary business takes place within that. Would that be correct?
That's correct. The suggestions were partial waivers, that perhaps they submit tax returns, and if they make more than a certain amount, then they'll get a 50% or that's one way, is to make it partial waivers based on proof of income and the business movement. You could also proof of economic hardship. And you make sure that the waiver is only for 1 year period, or to do some sort of limit. And we had gotten language drafted for you submit a waiver, but there was no backstop as to ways of making sure that you don't have a statewide emergency. All of your licensees request waivers. Where do you go from there?
Right, and that raises an interesting question. At that point in time, is there state monies set aside to offset those losses? Has that even been discussed?
I haven't heard it being raised, but I talk to the budget folks, so I will ask them, since the legislature has created this and other boards may do this also.
Right, yeah, okay. Thank you. All right, Trish will continue.
Thank you, Karen. Okay, on page 10 of the program manager report, historical pass rates for the California Supplemental Examination performance data for the period July 1st through February 28th is included, as well as the comparison data from last fiscal year. And regarding the layer administration is being held now. The administration period is March 28th through April 9th. Also, the CLARB job task analysis, which is used in the development of the layer content, is underway. Upon conclusion of the JTA, the Office of Professional Examination Services will conduct a linkage study between the JTA and the most recent California occupational analysis of the landscape architects. The intra-agency contract was executed in March for this fiscal year ending June 20, 2023. In the amount of $26,212. Upon completion of the linkage study, the OPES will present its finding to the LETC at a future meeting. Also attached, just as an update to the committee, is the executed contract for the ongoing development of the California Supplemental Examination for fiscal year 22-23. The maximum amount of the contract is $23,808. Moving on to LETC Enforcement Program, effective January 1st, all applicants for licensure are required to submit fingerprints to LETC. Staff are successfully receiving the fingerprint reports from the Department of Justice using licenses with the new issuing licenses with the new requirement, and have not opened any conviction cases as a result of fingerprinting. And referring to the chart, there are no enforcement actions to report since the last meeting. The LETC opened 8 complaints during the third quarter and closed 6 cases, which averaged 209 days to close. And there were 11 pending cases for the same period. No citations were issued. This concludes my report. Please let me know if you have any questions.
Trish, yes, I do have a question. In regards to this last statement, there have not been any more or less conviction cases opened as a result of fingerprint submittal. What exactly would that be?
If there was a conviction that was identified as a result of the fingerprinting, then we would open a case and determine whether or not it meets the requirements as outlined in the disciplinary guidelines, if they would be issued a license or not.
Okay, so that would be the FBI would be providing that
They
as
get
part of
a
the
state
background.
and federal background check.
Okay, all right, thank you.
A quick question, John?
Yes.
Chair. It's only for new licensees, right? The
Yes.
people that are already licensed?
That's correct.
All right. Any other questions from the committee in regards to the admin report?
Mr. Chair, I don't know if this is the appropriate time of the meeting to discuss it, but do we want to have any kind of discussion on the CSE performance? I mean, data is provided to us. Do we want to discuss what that data includes and if we can draw anything from it for any substantive reasons or any future changes we might want to make? Or
Yes, simply yes.
okay.
Because I do have a few questions myself on that. Any of you would like to start that discussion, raise any initial questions?
Well, I guess I'm just trying to, as we look at the data that's provided as to the pass and fail rates, it seems like the pass rate for first-time candidates is hovering in the 60% range, and the failure rate still hovers in the 30% range. So, which I guess would then lead to is the test itself, in its current form, is it being effective in doing what it is that it's intended to do? Mm-hmm. So I'm just bringing it up only just from the standpoint of I don't have positive or negative input for it. It's just that we get this information provided to us, and obviously it takes time to put this together. It'd be nice if we could, devote at least a little portion of our meeting to the testing, so that we all have a better understanding as to, okay, what it is, what it means, what may need to be improved. And I understand that it's based on the candidates that are taking the exam are going to vary from year to year or from testing to testing. And some years you have people who are maybe more knowledgeable in those items that are covered, and sometimes you're going to have people that are less knowledgeable. So I understand there's going to be a variation, but it's almost like, over a period of time, do we need to evaluate and see how effective this testing is? Because we're requiring it, and we're requiring it for all, not only all candidates to take, but even our reciprocal license candidates, have to take this. So again, I've been asked on more than one occasion, why are we having to take this? Kind of a thing. Isn't the national exam sufficient enough? And of course, we come back and say, well, no, California's got its own specific criteria and requirements. So again, we just need to be consistent with taking a look at the information that's provided in these reports. So I'm just kind of throwing it out to the rest of the group. And if somebody else has any comments, about the candidate performance charts.
Yeah, I just to throw my observations on here, looking at specifically the most recent exam period, that the repeat candidates, I'm a little alarmed by that. That's definitely a significant difference between those passing and those that are failing. And I'm just curious if, in analyzing those rates, are there any studies or anything that are looking at specific items on the exam itself that might be associated with that significant failure rate? Also, looking at the FY 2021, it seems that the pass and the failure rate seems definitely very similar, irregardless of whether they're taking it for the first time or repeating it. And I would think that if you're repeating the test, that you would have some familiarity with it, and that it would be anticipated that the pass rate would be higher than what it actually is. So that sounds like definitely an area that we need to look into a little bit more. I would also say that I have concerns that with the national exam itself, it seems that California tests a little bit differently than it seems the national average, and I think that's another area that we need to look at, and that may be directly tied to the same types of results that we're seeing with our own supplemental exam.
Yes.
Any
thank
other?
You. Yeah. My question's about the repeat people, the 71%. How many times did they repeat? Is it just the one time that they repeated, or are the same people taking it more than once and failing multiple times? And also, is it the test problem or is it the qualification problem? And now that we've opened this up to other professions, and to see the rate going from 33 to 71% fail, is it that we're bringing in other professions that don't have the experience in the exam, or is it that the exam is too challenging, which I don't think the test is too challenging. So that would be, and so how many times have people repeated, and is it experience or test?
So the repeat total includes individuals who have taken it, repeated it once or more than one time. So it's a cumulative total of those that have repeated.
But we don't know, are the same people taking it 3 times and bringing this rate up so high, or is it one repeat? Do we have that kind of numbers?
I think we could break it down. Yeah, we could obtain that.
That'd be good to know.
Chairman, I have a question also.
Yes.
Okay. So the other statistic that looks a little interesting to me is the number of people, from, 2021, there's 75, and then 21, 22, there's 39. That's almost like half. And so I'm just wondering if we see that kind of fluctuation typically, or if that's, unique.
I think that might have been. I think that Clark also observed similar decline in candidates, and that's probably why we're also seeing if there were less candidates that took the national exam, and I believe that's partially due to COVID.
Might it also be that the bottom one, which is fiscal years 2021, is a full year, whereas July 1st, 2021 to February 28, 2022 is only 6 months, or 7 months, whatever it is. So,
Yeah, the other comment that I'd like to make is in reviewing the environmental scan that was done, there were definitely a number of comments in there that clearly stated that they thought that the supplemental exam was fair and that it was a good test for qualification. So I think looking at our licensing cohort, they're not identifying the exam itself as being the problem. However, looking at the statistics, there's obviously some issues there. I think it's going to take some work to kind of dig down into that. So what I would recommend is perhaps in our strategic planning session tomorrow, we might consider adding an item in there that might begin to address that question. And if nothing else, that we definitely agendize this at a future meeting to dig into this a little bit deeper.
I did kind of have a reason for bringing this up initially, and that is getting back to the whole CLARB discussion, which I know we're going to have here in just a little bit, and then maybe even more tomorrow. But again, when you start talking about state requirements and licensing in general, and trying to standardize licensing across the country, and then we see these kind of pass rates or failure rates, whichever one you want to look at, it kind of plays into that whole discussion, in my mind anyway. So that was one of my reasons for why I wanted to bring it up at this portion of the meeting, seeing as how we had the information in front of us at this point, and we may want to come back to this when we have that discussion on the CLARB proposal.
Pamela?
Yes, thank you, Chair. In my mind, what had come up was exactly what Susan had mentioned as far as opening up and our pathway to licensure and in broadening that there in that could certainly be a change. People may not be preparing as much as they maybe think they are ready for the exam, and then they're finding upon taking it that they need to do either get more experience or study more for the exam. I also wonder about the fact of COVID and the fact that those entry-level positions are not getting the day-to-day collaboration that we had in studio time prior to COVID. And I think there's a world of benefit to that, looking over someone's shoulder or being able to go over to another project that maybe you're not working on, but seeing that process and having more mentors at your, day-to-day fingertips. So I think there's a lot of things that could be getting us to these rates that we're all not necessarily comfortable with. But I do think as we increase the path to licensure, and something that Andy brought up to me years ago when I was not on the board, was that as we open this up and enlarge the pathway to licensure, what we're really doing is saying, if you have this sort of experience, then you can sit for the exam. It's not guaranteeing that you're going to pass it, but it's allowing you to sit for it. And so in this, I think we should prepare ourselves perhaps for more numbers like this in the future as we're opening up, because I don't think it necessarily means that everybody is going to be, they're not going to be from an LAAB accredited program. Maybe they haven't had the 2 years experience, in the same way that it used to be set up. And so I think there's going to be some fluctuation in the pass rates. And I just wanted to bring up that I think there's a lot of things that could be contributing to this, COVID being one of them. Of course, it's affected so many things, right? So, thank you.
All right, thank you.
Back to what breakdown of these numbers, do we have percent passed by these alternative, like is the geologist the one that fails as a category, or is it the civil engineers, or is it the work experience only versus education? Do we have that kind of breakdown?
So we do collect that information, but we have a workaround system right now, and it would be a manual process to retrieve that data. And so I believe it was brought up at the last meeting where what staff plans to do is, once we have the new business modernization platform available and all of that information is in there, and we can easily extract qualifications and various pathways and fully understand it that way, we'll be able to present that information to the committee.
Great, thank you.
Chair Wyszynski?
Yes.
I'm getting concerned that we're a bit off the agenda here. We're on the program manager report. So at this point, I would recommend that if the board wants to have more of and continue having a substantive discussion, that we place this on the agenda for a future meeting. I do think there's room, though, to have some discussion of this in the strategic planning session tomorrow.
All right, thank you for that. All right, any other?
I do have one more
Yes, Andy.
comment, though. In all due respect to Michael's comment, though, seeing as how this is presented for our review and I'm assuming our comment, I guess I would just want to ask a question. One of the things that Pam had brought up that I hadn't really considered is that we're looking at data that is from COVID years. How does this relate to years that were non-COVID? And so I don't know if we just expand the chart a little bit more so it includes a little bit more information. That might be helpful. Fully understanding that even the test itself, the CSE, is changing or has changed or whatever. So again, more information might be a little bit more enlightening. So that's all I need to say about that. Thank you.
All right. Hearing no further questions or comments, we will move on to item G and ask Laura to present this item.
Thank you. Okay, so let's see, I'll start with Assembly Bill 225. This is a 2-year bill, so we may have discussed it last year. But this bill expands the provisions of the existing military spouse temporary licensure program to apply to military veterans who have been other than dishonorably discharged, and to active duty military members with orders for separation in 90 days. So again, just expands that existing benefit a little bit more. This bill is awaiting hearing on the Senate side, then the Senate Business Professions and Economic Development Committee. Are there any questions? Okay, AB 1662 by Assemblymember Gibson. This deals with potential applicants who could be disqualified from licensure due to a criminal conviction. It would allow a prospective applicant who's been convicted of a crime to submit a request for a pre-application determination regarding their criminal conviction. And this request can be submitted before the applicant obtains any required training or education, and it doesn't authorize a board to charge a fee for this service. So kind of raises lots of policy procedural questions on how we'd implement it and how we deal with it. But hopefully some of those questions will get answered if this bill moves forward. It's going to be heard in the Assembly Business and Professions Committee on April 26th. Are there any questions?
Yes, I have a couple. In reviewing the legislation, the bills that are in here, it seemed to me that Senate Bill 1365 is sort of parallel to this. I mean, there's enough overlap there in my mind that depending on what happens with one may have to be dealt with in the other, or if they're both implemented. Is there any chance that these would go to reconciliation between the two houses and that would be worked out?
They definitely deal with the same topic, but probably go about it in different ways. But I don't think they're that close enough that they would need to go through maybe a formal reconciliation process, but they would have to have, usually it's just like technical chaptering out language. So if they both amend the same code section, they need to address that back. So the governor has the option to sign one, both, or neither if they get to him. So that'll definitely be a part of the process. But then I think also the policy committees will look at the changes being made by each bill and look at what else is out there and see, you know, if this is the direction they want to go.
Okay, I had another question. There's a section in here that it's describing the licensing authority shall retain all of the following information, and then it lists 4 items. The number of applicants with a criminal record, the number of applicants with a criminal record who provided evidence of mitigation or rehabilitation, and then the last 2. And the question that I have is, do the boards retain that information presently, or is this a new requirement? Because I'm not seeing any strike-throughs or anything in here or indication that this is new language. So I'm just curious.
That's a good question. You're looking on page 5 of the text? Yeah.
Yeah.
So that should be existing language then, existing law, yeah, in 480. So yeah, so we already do have that data.
Okay. Because one question that immediately came to my mind is how many applicants typically fall under this where they have some sort of a criminal conviction that are following this process as a part of their application currently?
I mean, it definitely varies by board. For our board, for both architects and LATC, we wouldn't have really had, it was voluntary data, right, until we started fingerprinting. So, but it's pretty low for both of them. Definitely in other professions, it could be quite a bit higher.
Mm-hmm. Okay, thank you.
Thank you. So any other questions on 1662? We'll keep you updated on this one as it goes forward. It's a different approach. So, okay. So the next one is AB 1733. This is the one that Brianna touched on in her DCA update. So this would make permanent changes to the Bag Leaking Open Meeting Act to give boards the flexibility to meet similar to how we were meeting during the pandemic in the WebEx format. It does make some changes to require one location for public access that would be required at each of those meetings, but would allow meetings to go forward in either a hybrid option or, in a remote option. So it would be, we're just watching to see what happens with it. It would be nice to get some permanent authority. It is an urgency bill, but it is, it's going to be heard in the Assembly Governmental Organization Committee on the 20th, but it has to go to 2 policy committees on the Assembly side, and it's going to have to go to the Senate process. So it's probably going to be at least a little while before this bill makes it to the governor, assuming it does. But
Yes, I had a question. I'm assuming the way that I've read this is that if you're meeting remotely, that it has to be in a public location. Is that correct?
Michael can correct me if I'm wrong, but it means that you need to have one location designated that the public can go to. So it could be that the board or committee is meeting remotely, all of you are participating like you were, but we have one designated location that's noticed on the agenda the public can go to make comments. And so I think DCA, assuming this bill is signed, will have a few rooms like in Sacramento that can be used for that purpose, potentially in Southern California. So we would just have to pick one location. But that is something to consider as, if we go back to the pre-pandemic trying to meet on university campuses, we'd have to make sure there's that WebEx capacity, which doesn't always exist when we meet outside of DCA facilities.
Right, because the question that I had is, let's say any one of us is participating remotely and they're at their home, does that have to be designated for public access?
It doesn't. Under the Open Meeting Act now, it does, and you have to include it on the agenda, but not under AB 1733. Am I correct, Michael?
That's correct. The current rules that are in effect now that the governor's executive order has expired are the traditional teleconference rules where we could have a meeting via WebEx or via phone link, but all of the members' locations would have to be both publicly listed on the agenda and open to the public. And some of the guidance that DCA provides, or that I would certainly provide, is that a private residence not be included in that. Appropriate businesses, offices are at times better locations because you do have to accommodate any member of the public who wishes to attend at that location.
All right, thank you.
Thank you. Are there any other questions? Okay, we'll keep you updated as this one moves through the process. I think we're all looking forward to seeing if that can become permanent. The next bill is SB 1237, and I think I need to verify. I think it's been amended since the packet was printed. It used to have a fee waiver, but now under existing law, boards have to waive CE and fee requirements for personnel called to active duty. This bill just defines the phrase called to active duty to include active duty in the U.S. Armed Forces and on duty in the California National Guard. So it's a little bit narrower than when it was first introduced. And it's going to be heard in the Military and Veterans Affairs Committee on April 27th. There aren't any questions. The next one is SB 1365. This bill requires all boards to post a list of the criteria they use to evaluate applicants with criminal convictions on their website. And we generally have this information as part of our disciplinary guidelines, so that part shouldn't be difficult to implement. But another requirement of the bill is that DCA would have to develop a process for each board to use in verifying applicant information and performing background checks of applicants, and then a procedure to provide for an informal appeals process. I'm not quite sure what that would entail, but we look forward to seeing if this one moves forward. This will be heard in the Senate Public Safety Committee on April 26th. I'm not sure if that informal appeals process it references, it may be like the process we use for a licensee who receives a citation. They can appeal through an informal office conference, so something along those lines. Are there any questions?
Yeah, I just have one question, and it kind of goes back to looking at this paralleling Assembly Bill 1662. It seems to me that in reviewing these convictions of a crime, is stated substantially related to the qualifications, functions, or duties of the business or profession for which the application is made. And I guess the question that I have is, in some respects, that seems extremely nebulous because unless we're looking at, say, reading the Practice Act, and unless it's an actual violation of one of the conditions in there, is the intention to limit it to that, or is it anything that might be construed to be a threat to the public health, safety, and welfare is what the aim actually is?
I'll defer to Michael to answer.
Okay.
So Chair Roshinsky, that is a feature for the most part of existing law, and it's actually based on due process requirements, but it is not limited to specific violations of the Practice Act. I think you said it quite well. It's more formulated in terms of public protection. Like, would you want a professional that has several or even one or more convictions for driving under the influence is a good example of that, because the concern is that they may be practicing under the influence of alcohol, and also convictions that involve dishonesty or fraud or theft, for instance.
Mm-hmm. Okay.
Yeah, I would agree. It is sort of nebulous. That's a good word for it. And it's also because it applies to all boards within DCA. And so what we might consider substantially related to our profession is quite different maybe from the medical profession. But it's broad authority.
Mm-hmm. Right. Thank you.
Okay. And then the last bill is SB 1443. And of interest to us is this is the bill that will extend our sunset date for an additional year. So I guess the good news is that they're willing to extend us a year, which means that we're not a problem board, which is great, but it does, present some other challenges. So, but it does give us additional time to work on our sunset report as well.
Mm-hmm.
Thank you.
All right. Thank you. Any further questions, comments from the committee? All right. Thank you very much. Well, the next item on the agenda is the CLARB discussion. It is a little after 11:30, and I would propose that we postpone the beginning of this until after lunch. But what I would like to do, maybe to fill a little bit more of the time, is to move item I, which is review of future committee meeting dates, and we can take care of that now.
Chair.
Yes.
As you know, we have a meeting in Campbell at our city hall, and I'm willing to offer that because it says to be determined on locations. And if that's something you guys want to come back to Campbell, we would more than welcome us.
All right. Thank you.
So I'll present that under agenda I, the next LATC meeting is scheduled for August 2nd. Prior to that, there is a board meeting next month on May 20th. I think the location is still to be determined, to be somewhere else in the Bay Area. So if there is a member that is able to attend that meeting, we can discuss that here at today's meeting. The CLARB annual meeting is scheduled for September 21st, 23rd. And
Yeah, that is actually in Omaha, Nebraska.
correct. And then our final meeting will be November 1st. So if we could maybe talk about who might be able to attend the May 20th meeting.
That is definitely going to be in Northern California. That board meeting.
That's a good question. John and I talked about this yesterday. It was originally planned for Marin, for other reasons. I think we're going to move the location, but I think it will be in San Francisco or Oakland. We're looking to have it at a college or university facility. So that's our plan. I think we're going to have it narrowed down, hopefully identified this week, as we need to get moving on our planning of that. But it'll be a one-day meeting.
All right. Do we have any volunteers to attend that at this point? Or is that to be discussed at a future time?
Trish, I have a question. I had raised my hand at the last meeting for what I thought was a CAB meeting.
You did.
Do you have that, or did they move that date?
No, we didn't move any dates. I didn't bring, you did raise your hand, and I think you might have volunteered.
Was it for this May 20th?
I'll have to get back to you on that.
Okay, and I can check my calendar
Sure,
just a
okay.
second.
If you can't do it, I could do it.
Okay, great. I'm just gonna check our minutes real quick.
I do have that on my calendar, Trish.
Oh, for May 20th?
Yes, for May 20th.
Okay,
And I
great.
can still attend.
Wonderful. Thanks, Sam.
You're welcome.
Okay. Anything else you want to talk about on the schedule?
I guess the only other thing that it's not listed on here, but we will be discussing after lunch, is the April 20th CLAR meeting where we'll be registering our vote on the 3 resolutions. So we will discuss that after lunch.
Yeah, and for that meeting, we have it in here. All LATC members are invited to attend.
All right. If there's no other questions, comments on that item, we will break for, how much time do we want to take for lunch?
He just left, so I think at this point we can go 30 to 45 minutes. I'm not sure. I'm not sure when
Okay,
it'll be.
let's see.
Yes, it'll be right here.
Yeah.
Maybe,
Why don't
maybe
we?
12:15.
Why don't we say 12:20? Okay, we'll be in adjournment until 12:20. All right, we're reconvening the meeting. I have 12:22. We will commence with item H, Council of the Landscape Architectural Registration Board. And I will ask Trish Rodriguez to introduce this item.
Okay. The Council of Landscape Architectural Registration Boards has been discussing proposed uniform standards and presented its recommendations to the LATC on September 4th in 2020. LATC Chair John Roshinsky provided 2 letters to CLARB on September 17th of last year and November 9th, addressing discrepancies and concerns between California's current licensure requirements and the proposed standards. CLARB rejected LATC's concerns and announced on January 12th it will hold a mid-year meeting on April 20th to vote on its proposed uniform standards. In response, the committee appointed a subcommittee consisting of Chair John Roshinsky and Vice Chair Pamela Brief at its meeting on January 27th to prepare recommendations on the CLARB uniform standard resolutions and present to the LATC at today's meeting. The subcommittee held several meetings along with staff up until last week. Amendments to the resolutions were due to CLARB yesterday, April 6th. The subcommittee prepared an amendment to Resolution 3, which was submitted to CLARB and is included in one of the handouts for today's meeting. In addition to voting on the resolutions at today's meeting, the LATC is asked to discuss and take possible action on the letter of credentials for CLARB's mid-year meeting and the invitation from CLARB for an LATC representative to be a part of a new work group in 2023 to evaluate the outcomes of the CLARB job task analysis. The invitation is included in attachment H21. I'll hand it over to John to discuss each of the resolutions and the subcommittee recommendations. John?
All right, thank you, Trish. And I don't even know where to start. What we have before us today, what we've been asked to do is to address 3 specific resolutions that CLARB has put forth. Resolutions 1 and 2 relate to the adoption of a uniform standard, and resolution 2 is, if adopted, these are the recommendations vis-a-vis a change in the model law on how those standards are to be implemented on a state-by-state or jurisdiction-by-jurisdiction basis. The third resolution specifically addresses CLARB's effort to bring DEI issues to the front, and primarily looking at removal of specific language that currently exists in the model law that has been deemed offensive to that process. So with that, I will I guess first move to the letter of delegate credentials, and I'm trying to figure out where in the package.
It's right after.
Okay. Maybe a little overview on the meeting on April 20th. There has been a specific set of rules that have been set up for that meeting. H1, it should be right. Second page. Yeah, there you go. And as a matter of fact, I think, isn't there, let's see, the rules. Well, anyway, the way that the meeting will be run is that the first action of the meeting will be to address any amendments that have been proposed and accepted for discussion during the meeting. Those will be brought up on an individual basis, and each jurisdiction that has put forth that amendment will be giving a short 2 to 3 minute period to explain the amendment and why they're asking for it. Each amendment will be voted on its own, will either be adopted or rejected. At that point, once that process has been gone through, they will move on to each individual resolution, and depending on whether or not any amendments to that resolution have been accepted, there will be a jurisdiction-by-jurisdiction roll call vote on whether to accept the resolution as amended. Once that process is completed for all 3 amendments or all 3 resolutions, the meeting will be ended at that point. At that point in time, CLARB will proceed based on the final tally of each vote to then move on to the next step, which is essentially to notify each of the member jurisdictions the official outcome of each vote, and what their thoughts are on how to proceed. CLARB has stated a number of times that in voting for the resolutions does not obligate any jurisdiction to actually implement those. However, it is clear in the CLARB bylaws that any decision that is approved by the membership, it's expected that that be implemented and supported by each jurisdiction. So there's a conflict in and of that that particular issue. So in order to officially register our vote with the CLARB at the CLARB meeting, we have to have a designee who will actually make the roll call vote and make any comments on each amendment or each resolution at the appropriate time. Typically, in the past, the way it's run is there is a member of the committee who is that designee, and then as the board executive, Trish would also be in attendance at the meeting to represent the board in that capacity. There has been an invitation put out that all committee members are welcome in the meeting, but no one other than the official designee will be allowed to vote or make comments. So they would just be there strictly as observers. So with that, we need to designate who the official designee will be, and then that will be put together in this form letter and sent to CLARB prior to the meeting. So I will ask for a motion or recommendations on who that designee should be. I will self-nominate myself for that, but we'll take any other comments or suggestions from the committee.
I'll second the nomination.
All right. Any questions, comments?
Are we ready for a vote?
So we have a motion.
So I will take Susan's second as actually a motion, and then I'll ask for a second since John self-nominated.
I'll second.
Thank you, Andy. I'll call you by name, and please recognize your vote. Susan.
Yes.
Pamela. Yes. John.
Yes.
Andy.
Aye.
And Trish.
Yes.
Unanimously, Mr. Chair, you are our nominee.
All right. Thank you. We will then move on to Resolution 1, adoption of the CLARB Uniform Licensure Standard for Landscape Architecture. So as mentioned, Resolution 1 pertains specifically to adoption of the CLARB Uniform Licensure Standard as submitted to the membership. At this point in time, unfortunately, we do not know if there will be actually any amendments to that. It'll probably be sometime next week that we will receive any amendments to review. So I guess one question that I have is that because our meeting obviously will be adjourned at that point in time, what should be the process that as a committee we want to address any potential amendments that come forward? We do know that we submitted one, and that will be discussed as part of the Resolution 3 discussion. But as far as Resolutions 1 and 2, we have no idea at this point in time what that might entail, or if there might be amendments dealing with any other issues. Yeah, I'll also, at the last meeting, we did convene a working group, which consisted of myself and Pamela Brief, to look at each one of these resolutions and develop a recommendation. I think Trish kind of laid it out that as far as the uniform standard itself goes, we've had a pretty good idea for probably the last year and a half of what that was going to be. Although there were some changes that were placed in that at the 11th hour. And we had submitted 2 letters to CLARB previously, basically stating our concerns as proposed, and basically did not receive a positive response to either one of those. And so based on that and the thorough analysis that the working group did, we have developed a series of recommendations on how we think the committee should vote presently in regards to each of the resolutions. At this point in time, I would also like to add that I think irregardless of any possible amendments that might come in for these resolutions, that we should probably stick to our recommendation and work out any differences in the future at that point.
I have
So-
a question.
Yes.
I might be premature in this, but what happens if they don't accept the amendment? And then as a state, we're the state's saying one thing, the uniform standards saying something else. What happens? I mean, we're contradicting to California state rules that passed.
Right. We are not obligated to implement any of this should it pass, but that does not alleviate the question of what friction, as CLARB has put it, might still exist moving into the future. If in the case of California, the proposal would definitely result in a more restrictive process for applying for licensure, based purely on the fact that there would be additional experience years required above and beyond what California already provides, and also California offers, as far as alternative pathways, offers a number of other alternatives that CLARB would not recognize, and as far as the uniform standard goes.
So in summary, basically, if I come in and I have my 6 years and I go to apply, they won't let me take the test.
Well, under California law, you would qualify, and you would
For our California section or for CLARB?
for both.
I guess I'm getting confused of what, if you could still take the test and you could still do that, do we don't need to comply with this then?
No.
So what is the implication after that then?
Well, there might be implications in regards to reciprocity, and that would be on a jurisdiction-to-jurisdiction basis in the future. But if a jurisdiction, say, did adopt the uniform standard and requires for their own licensees to have that additional time, it may be an issue that when a California licensee applies for reciprocity, they may have to provide evidence that that additional time was gained through employment or some other means.
So basically, it doesn't affect people in California, it only would affect if you wanted to go to another state. Reciprocity.
If I could.
Sure.
And Susan, I think one thing to be noted, it would depend on what that actual state has done, not CLARB as an overarching agency, because each state is given the jurisdiction to adopt its standards. What CLARB has done in this case is taken, 52 roughly recipes and tried to hone it down into one. Now, granted, we let them know that the direction that they were going was still more restrictive than the regulation that we have adopted. And those were the 2 letters that John wrote, and they did not take that under advisement. We have had specific, as the subcommittee, we had specific conversations with them about these discrepancies. And the response was, we don't expect states to necessarily adopt everything in CLARB at one, all at one time, but maybe take baby steps. And a conversation that I personally had with Elizabeth Hebron from ASLA, I made it very clear that there were no baby steps to be taken because we would be making baby steps back unless they could supply us with data that clearly stated we were impacting health, safety, and welfare in our current legislation. But noting that the current legislation and all of our research is how we got to where we are now. So that's basically in a nutshell. But we are still, as the state of California, allowed to hold with the regulation that we currently have.
Okay, great, thank you.
So that is primarily Resolution 1. Again, Resolution 2 is revisions to the CLARB Model On regulations to align with the draft uniform standards. So if Resolution 1 fails, then Resolution 2 becomes moot. And vice versa, if it passes, then it's expected that Resolution 2 would be adopted, and that would be the model going forward. So at this point in time, I would like to open it up to any questions, concerns, comments, or anything from the committee in regards to what's been presented thus far with Resolution 1, adoption of the uniform standard. I would also like to point out that with the uniform standard, in regards to the alternative paths to licensure, it's not really clear exactly what that is going to mean moving forward. CLARB has provided their idea of what alternative pathways would be, but it's very limited and narrow, and it states that it will be left to the states to essentially develop their own criteria to measure those alternative pathways and develop the credits that would be allowed. So in that regard, and that's always been the issue with us and with CLARB. Recommendation has been on the alternative pathways, because we can all agree that if you have an accredited degree from a professional program, that will continue to serve the same way that it always has, with the exception that now CLARB is stating that you have to have a total of 8 years education and experience. And the one thing that they have done in describing the credits for both education and an experience in the uniform standard, they have given 6 years credit for an accredited degree, rather than if it's a 4-year degree program, it would be 4, in California, and you would work for 2 additional years to gain the 6 years that we currently require. So when it was put to the CLARB leadership, why suddenly at the last moment an accredited degree was elevated to 6 years credit, they could not explain that. And I know I personally registered concern with that, and I know that there were several other jurisdictions in that meeting that also raised that concern. Not so much the fact that, okay, we're going to give 6 years credit, but the fact that nobody could explain where that decision had come from or why they decided that it was worth 6 years of credit versus 4. So,
Mr. Chair,
yes.
do you explain, or did they explain where they came up with 8 years?
The way that I understand the process is that when they began looking at this, in order to establish a baseline, so to speak, there was a company that was hired that did this analysis for them that looked at each jurisdiction, what their current regulations are, what types of credits that they give and that type of thing. And then they tried to whittle that down into some kind of uniformity. And it was never really clearly explained really how they arrived at that number. We were just told that based on the analysis that nobody ever actually saw that's what they had come up with. And that I think it was partly because when they looked at across all the jurisdictions that there was a pretty wide range of years of experience and education between the programs. And my guess is that they probably looked at all of that and kind of came up with an average and said, well, to make the real outliers kind of fit in, we figure it's 8. We know in instances like in our case with California, they currently require a total of 6 years credit. And so I think it basically just came down to the math that they were doing. And they never really adequately explained that, although they were asked several times how they arrived at that. But my experience, and I know Trish has been in most of those meetings, it just really bothered me, the process. It was always sort of, trust us, we know what we're talking about, we know why we're doing this, but nobody ever really explained how they actually arrived at that. So.
It kind of seems to me, though, that California is like the elephant in the room. I mean, we probably have the most number of licensees in the entire country. I mean, not as an aggregate total, but as a representative, of the states, of the different states, we probably far exceed all the other landscape architects from each individual state. So I would think that they would tend to want to listen a little bit more as to what we may need in order to, follow along with our regulation. I guess a question that I've been mulling around here is, what would our position be if at the meeting, and let's say there's enough spillback from other jurisdictions saying, well, 8 years is just too much. And they come back and say, well, okay, I tell you what, let's make it 6 years. What would our position be? Will we be supportive of it if they went to 6 years? Or would we still not be able to support it because they don't allow these other additional pathways that we support? In other words, is it an all or nothing kind of proposition?
Well, That's a good question. I've asked myself that many times, and it's kind of the dilemma. But that gets back, as far as the alternative pathways go, that gets back to the question about what exactly does that term mean? Because we've asked that question, and it's never really been explained why they limited the alternative pathways in the uniform standard to what they did, and yet at the same time they say it's basically up to the states to decide how to administer that part of the process.
Can I add
Mr. Chairman.
Yes.
To add to that answer, Andy, it's twofold. There's our California regulation has a much broader pathway, as you know, but there's also discrepancies. Like even if they went to our same number of credits for a degree, the 4 versus the 6, there'd still be discrepancies in the number of years of experience you need. And this chart that we put together kind of helps show that to some extent, with the red being the years of experience. And so this was helpful for us to see, because it starts to get sort of confusing, as you're going through, because of those difference in years, the 6 versus the 4. So if they took it down to 4 years, we still might not vote yes, because there's still more years of experience required under CLARB, and there's more pathways available under LATC.
I guess that, Mr. Chairman, I guess I'm just wondering a little bit more about this committee that CLARB put together. And, did you get any kind of history on how they chose the people that are on the committee? Because just kind of building on what Andy said, I mean, we are the elephant in the room. I mean, we should have had representation on that committee.
Right. I cannot tell you how the committee was selected. They've made it known who was on the committee. But it was never explained why they chose the particular people that they did. So that's...
If I recall correctly, looking at it, I was kind of surprised that, the states that have the most licensees, like Texas and New York and Florida, they weren't represented either.
Right. Yeah. Yes. Susan?
Sorry, where do we stand from how many other states have their own separate license like we have? Does every single state have their own local license, or are we one of the only ones?
Do you mind if I comment? I think to get to your earlier comment, so CLARB can set a national standard, but they don't have a national license. They're just making a recommendation. It's up to each jurisdiction to set their requirements. So everyone has their own license, and CLARB is just recommending what they want that standard to be, but everyone's going to determine what it is for them. And so right now it does differ, but I think the majority of states follow like the CLARB recommended model, which is the accredited degree, as the only path towards licensure. So for them, they need this uniform standard to be adopted, because that's the only way they use.
There's 2 parts to the test in California. There's the
How many have a supplemental exam like
that's what
California?
I was-
Oh,
what I
that?
was looking
Okay.
for.
That I don't know offhand. Do you know, Trish?
No, yeah.
I'll see if I can find that for you. I was just about to go to their website. I'll check.
I know that there are other states that do have a supplemental exam, but I don't recall specifically how many.
and we have the most number of licensed of all the countries. We have the most number. What are we up to now? 6,000?
No, about 3,700.
Oh, I'm sorry.
What are we at, 87?
We have approximately 3,700.
currently licensed? What's the next state down? How many they have?
Well, as Patricia mentioned, it's probably Florida New York, and Texas. I can check on Clark's website as well for that.
I'm just curious because it goes back to Trish's comment about why were we not at the table as a state? I mean,
Mr. Chair, if I could opine on this subject?
Yes.
I think that it's important to know that you're not on an island. As you know, the California Architects Board has the same exact struggle with NCARB, in that we're the largest representative of membership, but has the fewest voices in the conversation. And so we're constantly challenging that ourselves. But I think that it is worth noting that if you recall, California at one point, at least when I was licensed, was independent of NCARB. There was some pushback by practitioners in that that certification denied them access to other states, as we had mentioned. California has since re-engaged and through that process with the supplemental exam, much like the landscape architects have as well. But I think that it's worth trying to figure out, as someone said earlier, what are the true implications of this separation, and what are the expectations of licensees in terms of how they engage their practice when there's a disconnect between you and the model structure. So thought it was worth noting.
Mm-hmm. Thank you. Mr. Chair? Yes, Andy. I don't mean to state the obvious, but I think we all recognize that this group, the LATC, has a responsibility to the people of California. And while I'm sure that CLARB might not like to hear this being voiced, but I think that's where our responsibilities lie. So we need to make sure that what we're doing is for the best of the people of California, and it may or may not align with what CLARB is saying that they want as a model law. Mm-hmm. Now, having said that, I think we also have to kind of recognize the fact that CLARB really bit off a lot when they decided they were going to take this on, because they had 52 different jurisdictions, or whatever it is, however many jurisdictions there are, which include Canada. And, it's like they're trying to come up with something that's going to satisfy everybody, and it's just not. I mean, you can try, and this was their attempt to. And while we can recognize the fact that and appreciate the fact of the amount of time and effort and work that went into it, and regardless of who the people who were on their committee, they worked diligently to come up with this. It's just that, unfortunately, it doesn't seem as though that their resolutions are going to be acceptable to the people of California. Mm-hmm. We have our standards. We recently changed our standards, and I don't think that we necessarily want to go back and open up that Pandora's box again. So my feeling is probably that we follow your recommendations per your letter, and we thank them very much for their time, and just say thank you, and we understand the difficulty of this, but at this time we can't, we cannot vote in favor of the resolutions. Mm-hmm. I agree.
good question. Since some of this is coming down to reciprocity, how many of us that are licensed here have reciprocity in other states? Do we know that?
Well,
Are you asking how many reciprocity licenses in California? Or how many California?
How many of us in California have a license in another
state?
We don't know the. And how many are we getting in that are requesting reciprocity?
I think we could run a report to identify how many reciprocity. Oh, sorry. I think we can run a report to see how many reciprocity applicants we've received.
I'm just curious.
Because it's really just part of our total licensed population.
Okay.
So I'd go off of reciprocity applications.
Okay.
mm-hmm. So another question that I would have, if I could maybe ask this real quick, is, and again, it has to do with reciprocity. Do we know for a fact that if we don't vote for this, but yet it passes through all the other jurisdictions, would our candidates not get reciprocity to the other states? Do we know that they won't accept it? I guess is what I'm saying.
At this point, I don't think we know that.
Okay.
Yeah.
So that would kind of be important, I would think, to know. Of course, if we raise the question, they're going to probably come back and say, "Oh, yeah, no, of course not. No, you're not going to get reciprocity if you don't vote for this."
Mm-hmm.
So
What I can tell you is that in the Clark Regional meeting, the Region 5 meeting, which included the surrounding states, Oregon, Arizona, they have all raised similar concerns that we have on this. And as a matter of fact, I know for a fact that the Oregon board has already voted not to support these resolutions. So
good to know.
that's what their intention is.
I wanted to add the 2 letters that John prepared were shared with the other CLARB member executives so that they could discuss potentially with their board members, and that might be part of the reason why Oregon voted the way they did.
Mm-hmm.
And it may be worth noting that, again, I was licensed prior during the disconnection between us and NCARB. I actually have reciprocity in 2 other states, and I am not NCARB certified. And so even though most jurisdictions will ask if you are, it doesn't by itself deny you access.
Mm-hmm. So, John, your comment is kind of interesting. If we already know that Oregon has voted no, do we kind of ask around to some of our other, maybe some of the larger states, the Florida, Texas, New York, and ask, kind of off the record, how are they feeling about it? Because again, I mean, it's one of these things where if the larger states, that have the larger, licensee populations, all are in alignment as saying, no, we don't want to follow this, I would have to think that CLARB would have to sit up and take notice of that. That they can't just say, oh, well, the heck with you guys, we don't care. Mm-hmm. So it might be nice if we had an alignment with other states so that we could kind of have like a little coalition to present our case for them so that they can maybe take our recommendations more into context.
Mm-hmm. Well, I can tell you that I can speak for California because we formally put that in a letter, our concerns, and sent that to CLARB as well as copied the other jurisdictions. We have not received similar from the other states. If there have been letters that have gone to CLARB as part of this process from the other jurisdictions, we have no idea because CLARB has not shared any of that.
There's no public information disclosure or information requests that we can make? I mean, there's what is the Act of Public Information? We get them all the time at Campbell where someone requests other documents. There's no provision for that to CLARB?
CLARB is considered a private company, and so they're not subject to that. Yeah.
No.
Mr. Chairman, I have a comment. So, I'm just thinking of different things, the information that you can kind of gather. And I recall LATC doing research on, the experience that was needed in each individual state. You remember that, Trish? So, I mean, my recollection, it's not like I memorized it, but my recollection was the average was more like around 6 years because, I felt good about that we were kind of consistent. So, if you had that data, as you go to this meeting, the 2 of you, maybe that could be brought up because you've asked the question, where did the 8 years come from? And you didn't get an answer. And, You know, I mean, you were saying, well, it sounds like they kind of did the math.
Right.
But I don't know. You know, I think it'd be good to just have that information at hand.
I know that as part of the work group, I spent time looking through regulations from a number of other states, including those major states, to see, and they all are much more aligned with us than they are with what the uniform standard is. I mean, not in every piece of it, but in general, they're more in line with us. I know the state of New York, they have a few things that are kind of out of the ordinary in regards to not the amount of experience in education that you need, but the way that they basically give credit. It's got to be certain programs that you go through, that type of thing. So, so Pamela, any other comments as the other committee member or the other work group member on Resolution 1?
No, I don't think so. I think you've covered, you know, what we found and the actions that we took. Yeah, I think we're good.
Yeah, I think it's important to bring out that ASLA was part of the committee that went through this, and Elizabeth Hebron was the official designee for that. I think in Pamela's discussion with her, there were some things that Elizabeth was not aware of, which you would think, yeah, like the letters that we had sent to Clarb. So it's obvious that I think whoever was actually running this process was pretty guarded about what types of information and things that they even shared with the committee itself. I wasn't there. That's, you know, I'm probably going to get sued next week for saying but you know, I mean, the entire process, to me, that's what really bothered me more than anything else. If they could have explained why they arrived at what they did and everything, I could probably live with that. But that was not the case. And they have been pretty guarded throughout the whole process. And in my mind, it just led to more questions than conclusions. And the reaction that we received from Clarb on a number of occasions just led me to believe that they were not really interested in what we had to say, or took a very neutral stand on what we were trying to raise, because most of the questions that were posed were more process questions more than anything else. Other than at the end when all of a sudden the final standard was put out there, and wait a minute, there's like these changes, significant changes in there that could not be explained. And so, and I believe it's not that they couldn't be explained, they were choosing not to explain it. And so that spoke volumes as far as I was concerned. I can say over the last couple of years that we've really been following this. I've really struggled with this because in some respects I think it probably benefits the profession if there is more uniformity from one jurisdiction to the next. But I think, and this is just myself speaking, I think the process that they choose to address this, as well as sort of the initial motives, I thought were kind of questionable to begin with. I think the main focus initially was that there was a real concern that a number of states were leaning towards deregulation, and in order to address those specific issues, they decided that the best way to do that was a one form fits all, or one standard fits all, would make it easier to defend professional licensure nationally. But I think it ignored where all of these threats were actually coming from, and that developing a uniform standard, in my opinion, is not going to make any difference at all in addressing those specific issues.
Is, when you vote, is it a simple majority or is it a certain percentage?
My understanding is the simple majority. So, and my guess is that all three resolutions will pass simply because there will be a majority of jurisdictions that will vote yes. And then we'll just have to live with that. But it doesn't mean that there won't be future discussions and concerns about that, because it's never really been explained what really happens after this, other than the fact that this standard will be in place and that there will be a model law that jurisdictions will be asked to implement. Maybe not immediately, but I think CLARB is looking at this as a long-term goal that everybody will eventually adopt the uniform standard, and that's what it'll be. So.
Are you done?
Yes, Susan?
No, I meant, Trish, are you done now?
Yes.
Oh, I guess I'm adversarial at this point. I still can't get over the fact that there's no disclosure. And, are they getting funding from somewhere that would help our argument of disclosure? It just seems like such an overriding body that affects all the states. Is there government money in there, or is there something that would allow us to have this disclosure and find out if other states are submitting letters, find out more of the background, like if there's meeting minutes we're not getting or something? A question for the lawyers? It does not seem right that you could have this without having full disclosure of how you're making these decisions.
Mm-hmm. I've looked into this. I do not believe that the committee itself that put this together, that there are meeting minutes available of any of those discussions. It's only when the committee brought their work to the full CLARB board that there are meeting minutes of that discussion, and the recollection in the minutes is very limited. So there's no explanation about process or anything. It's just this is what their committee brought forward to the CLARB board for review and approval, and that's the process that they utilized.
Have we made a formal written request for these other documents as to find out if other states have written letters? Is it in writing?
Not specifically, no.
So I would recommend that we make a formal request prior to the meeting on April 20th and put it in writing that we're asking for these, what other states have they written any letters?
The problem that I can see with that, though, is that we don't have enough time to, let's say we got the letters, what are we doing with them? But we don't have time to have another public meeting, and so we'd have to leave it to our committee, our subcommittee, to review those letters, and then they would have to speak for the rest of us. We can support that idea, I suppose, if that's what everybody thinks would be the right way to handle it.
Mr. Chair.
Mm-hmm.
Yes.
And not that it's not warranted to ask other states, what they're heading toward as far as a vote, but I just want to say that our charge is specifically as it relates to the state of California and the people of the state of California and how we choose to vote. So I'm personally not seeing how another state's vote would sway us or should sway us one direction or another. I think we should hold tight to that purview of like what's best for the state of California. And to add to that, I mean, we did exhaustive work and have a lot of research that backs up why we have the standards in place that we do. And I know that was a lengthy process. I wasn't part of the committee at the time, but I watched it very closely because it was of interest to me. So I kind of want to like shore us back to a, like almost like a tunnel vision in a way to really focus on our state.
That's a good point. I guess I was looking for support. Gang up on him.
Always nice.
Gang up on him.
Well, if it will be a roll call vote, and it will be alphabetical, so we'll be one of the first ones going. I don't know if that will sway, you know. I mean, there may be other boards that have been given direction depending on how certain votes go or whatever. We may change ours, but I totally agree with what Pamela is saying, that we can only speak for California, and that's how we should vote. And I feel comfortable with the recommendations that we've come up with in that regard. The only one that I think we need further discussion on is Resolution 3, because basically the amendment that we've put forward on that one, I think, would bring that issue in line with our current regulations, and I would feel comfortable approving that one in concept if our amendment is adopted. If not, I think we should proceed to vote no on that, because for any number of reasons. I know, I guess the question that I have is that on our agenda, we have a to vote on each one of the resolutions, and requesting a motion on each one. And then, so I don't know if what we want to do, if do we want to take up a vote, say on Resolution 1 now, or do we want to wait until all the discussion is over with and then vote on hold all the votes at the same time on that? I don't know if it makes any real difference other than procedurally.
Mr. Chair, I think that's within your discretion as
Right,
chair.
yeah.
I would recommend a motion for each item.
Right.
Because that could,
Yeah,
enough said.
yeah, we would have that, yes. Mhm. Okay, so we'll hold off on the actual votes, motions and votes until the discussion is completed. So if we move on to Resolution 2, as stated previously, it's tied directly to acceptance or rejection of Resolution 1, and I think for the obvious reasons that whatever we choose to vote on Resolution 1 will be reflected in Resolution 2. So why don't we move on to discussion of Resolution 3, which was based on revisions to the CLARB Model Law and Regulations to promote diversity, equity, inclusion in licensure standards and to align with CLARB's DEI principles. Again, it was never really clearly explained why the particular resolution was put together other than there was a decision that any question of an applicant's good moral character is in and of itself discriminatory, and that for that reason it be struck from the model law. And I know that there, in a number of meetings, there were a number of questions asked on that, and there were discussions involving that. And based on the working group, we decided that, and based on our current regulations, that we felt that it was sort of a disservice to just strike any mention of that from the model law, because striking it does not make the issue go away. And we felt, based on our current regulatory act, that it's important to actually have a statement there that addresses it, but states like ours does that it cannot be taken into consideration. It doesn't mean that we can't ask the question, because I think it is directly linked to criminal background checks, that type of thing. I think any jurisdiction would be out of line if they did not ask for background on any individual that we're going to provide a license to interact with the public. And so for that reason, I think it's important to recognize that those are important questions that should be and need to be asked, but it doesn't need to be the primary factor on whether or not someone actually gets a license or not. So based on that, the working group's recommendation was to, as proposed, to vote no on this resolution as well. But we did offer an amendment, hoping that it would bring it in line with our regulations. And if that's the case, what I would recommend is that we plan on voting no, but if our amendment is adopted, that we go ahead and vote yes on the resolution. It doesn't mean that there won't be, other DEI issues down the road that will have to be addressed, because I've always sort of questioned, is it a regulatory board's responsibility to specifically address these issues when the vast majority of things that affect that have absolutely nothing to do with what we're charged with overseeing. It has more to do with the schools, how are they vetting potential students, what types of opportunities are out there for people to enter the profession that we don't really have direct control over, other than maybe saying, if you take this pathway, this is how much credit that you get for doing so.
I would support your suggestion of we vote no unless the amendment is agreed, and then we vote yes.
Mm-hmm. All right. The other issue that we had raised with CLARB is that by increasing the total number of years of education and experience that are required to become licensed under their proposal would be more restrictive in the state of California, and therefore in some respects would be discriminatory, because there may be a number of individuals that can't afford to work that additional time, or for whatever reason. So that was another reason that we looked into and felt comfortable coming to the decision that we did. Any comments, Pamela?
I think my only comment would be that during our working group discussion, we did talk about the DEI principles, and that and we felt that by CLARB simply striking out good moral character from the standard did not by any means check the box of, yes, we've gone through a DEI process. And I think it would be more about CLARB being transparent about like what is their strategic plan? What is their plan on diversification of their board? Some of those sorts of questions and those sorts of responses to the community. So this seemed, although a starting point, certainly something that we would hope wouldn't be them feeling they had checked the box and that they didn't have to continue looking at this issue.
All right. I guess in so many respects, what else can be said? I can just say that from personal experience, it's been a very long process of going through this and seeing it evolve. Unfortunately, several steps along the way just failed to garner any type of real response in regards to our concerns as a state. I think we're close to the vote. In a couple weeks, it'll be all over with, as they say, and we'll just see what goes from there. So, if
I'd like to add a comment and thank you both for the tremendous amount of work this has been, and frustration as it goes with that, but it's certainly great for us that you guys are so involved and have done so much work. So thank you.
yes, and I would like to also extend definitely kudos to Trish and her staff who have done a lot of the heavy lifting on this, and would have been extremely difficult to get through this without all of your support. So if there's no further discussion, I guess we can move on to the motions to how to proceed with this. So on, let's see, so on, I will call for a motion on Resolution 1. And I guess
We'll ask reject or support Resolution 1, adoption of the CLARB uniform licensure standard for landscape architecture. So when I call your name, please indicate whether you reject or support Resolution 1. John,
First, we would need a motion and a second for each one. So the motion would have to.
Oh, I'm sorry.
The
Yes,
motion
yes,
will
yes.
need to express a position there, and then individuals can vote for or against the motion.
Of course.
right.
It's okay.
Do we have a motion to reject or support Resolution 1, adoption of the CLARB uniform licensure standard for landscape architecture?
I'll make a motion that we reject resolution number 1. That's the motion that we need, right?
Is that the motion?
That's all the motion.
I second.
Okay, Patricia seconds.
Right.
A call for a vote.
And please we're going to call for a vote. John Rosinsky.
Yes.
Andrew Bowden.
Aye.
Pamela Brief. Aye. Susan Landry.
Aye.
Patricia Trout.
Aye.
The vote stands as unanimous, and the resolution to reject Resolution 1. The motion to reject Resolution 1.
I'll call for a motion on Resolution 2.
I'll make a motion that on resolution number 2 that we vote no.
Do we have a second?
I'll second.
A call for a vote.
John Krasinski,
Aye.
Andrew Bowden,
Aye.
Pamela Breeth, aye. Susan Landry,
Aye.
Patricia Trout.
Aye.
The motion is unanimous. Resolution 2 is rejected. Do we have a motion to reject or support Resolution 3, revision to the CLARB model law and regulations?
I make a motion to reject resolution number 3.
I'll second that.
I'll call for a vote. John Krasinski,
Aye.
Andrew Bowden,
Aye.
Pamela Breeth, aye. Susan Landry,
Aye.
Patricia Trout.
Aye.
Unanimous once again. The motion to reject Resolution 3.
All right. The last item that we have to discuss on this is possible action on the CLARB workshop invitation to evaluate outcomes of the job task analysis. CLARB has reached out to the LATC to inquire if one of our committee members is interested in serving in that capacity. We don't know any of the details about when this will actually take place, or my recollection is that I believe that most of the work of the workshop or of this working group will be via Zoom call or something like that, but I do believe that there is a plan to meet in person at least once. I don't know when in the process that would be, but if we decide to offer a name for them to participate, I'm sure they'll get back to us at that point. So. Any questions, comments from any of the committee members? All right. I would just like to add, I don't know if this offer is a way of them sort of, saying, please forgive us for not, for ignoring you to this point. But I think it's important that this might be an inroad to having more of an LATC presence with CLARB. And so I would suggest that we definitely get someone to step into that. I believe that in their letter, I think was specifically addressed to me, if I'm not mistaken, in regards, and I don't recall if the offer was directed at me or if it was directed to LATC and they sent it to me as the chair.
It was the invitation to invite a representative from the LATC.
Thank you.
John, do you want to do it?
I would say yes, but something inside me says, one more thing. But yeah, I would agree to do it if that is the motion of the committee.
I would say it keeps the consistency, and you seem to have the most background. It would be you or Pam, but you seem to have been the lead, and it just seems like to have one of us, other people, it would take a while for us to get up to speed. And since it's such a hot issue right now, it seems like things are moving pretty quickly.
Mm-hmm.
So can I make a motion to appoint John as our representative to CLARB?
I second that motion.
We will have a vote. John Krasinski,
Aye.
Andrew Bowden,
Aye.
Pamela Brief, aye. Susan Landry.
Aye.
Patricia Trout.
Aye.
It is unanimous. John Brzezinski will be our LATC representative for the job task analysis.
All right, thank you. I think that concludes our discussion as outlined on the agenda. And we have, next item is recess until tomorrow morning, when we will reconvene, I believe, at 9 o'clock
Yes.
at the same location here, correct? All right, I will offer a last chance to anyone to make comments or questions before we convene for the day.
Okay, so tomorrow's meeting will be at 9 a.m. It'll be strategic planning, and that discussion will be facilitated by Solid, and the meeting will not be webcast.
All right, thank you. Well, hearing none, we are reconvened until 9 o'clock tomorrow morning.